Here's a story about a Missouri sexual molestation criminal case that's going to piss you off, and you'll see why I need your help sharing this information at the end. My name is Paige Sparks. I'm a Missouri lawyer, and this guy may get away with what he's been accused of because of an issue with how a warrant was issued, and that's why it caught my attention. In the summer of 2021, local law enforcement investigated allegations of sexual molestation of a 13-year-old child in Cass County, Missouri. After a medical exam, the child tested positive for a sexually transmitted disease, and in a forensic interview, the child said her stepfather, Israel Barrera, sexually assaulted her many times. In August of 2021, Barrera contacted the sheriff's office about the investigation, and based off statements he was making, like harming himself and about his emotional state, the law enforcement pinged his cell phone to locate him, and he was later arrested. The investigating detective obtained and secured a search warrant for Barrera's urine sample. The first urine sample could not be tested because it was not properly preserved, so the detective had to apply for 2 new search warrants. One warrant was for a sample of Barrera's urine, and the other warrant was to have the urine tested, but these new warrants lacked specific information about the molestation allegations, which would establish the probable cause for the testing. Both of these new warrants were presented to the judge who issued the warrants, and the urine sample was obtained and tested. The state later charged Barrera with 12 counts of statutory sodomy for conduct from 2019 to 2021. At trial, Barrera filed motions to suppress evidence of the urine samples, statements he made which could be construed to seek guilt, and the actual urine sample and test results, and he alleged that it should be suppressed because it was fruit of an unlawful search of his cell phone for having that cell phone pinged. He also requesting a hearing to establish if the search warrants lacked information to get what they requested, or if they had intentional misrepresentations by the detective. Based on prior Supreme Court precedent and the arguments at that hearing, the court sustained the motion to suppress evidence. That means the court said that evidence is not coming in at trial. The state immediately appealed because they needed all that evidence to establish that he did it. According to the docket, oral arguments in front of the Missouri Supreme Court about this case were yesterday, and it can take some time before the court will issue a decision. This case presents a legal issue for the Supreme Court to decide whether the trial court erred in granting that motion to suppress evidence, or if that evidence should be allowed to come in. If the evidence is not allowed to come in, it doesn't sound like there's much there to continue charging him or continue with the trial. This is a high-level view of the legal issues. I'm going to put the case and the case number if you want to read it for yourself. You can look it up on Missouri CaseNet for free. I've read both briefs, and I do think that probably the evidence will be suppressed, which is why I need you to share this, because this is public information. This case has been litigated already, and it's up on appeal in front of the Missouri Supreme Court. If this guy doesn't have to go through with the trial because he's getting out on a technicality, that's disgusting. I'll let you know if I hear any update on this when the Supreme Court makes a decision, and as always, comment to let me know what you think.